Hello everyone, this is Nidhi and welcome back to my channel all about law. As you can see, today we are going to talk about two forms of business organizations, that is limited liability partnership and a company. Okay, basically we are going to understand the differences between these two forms of organizations and the similarities between both of them. Now, what is a limited liability partnership? What are its characteristics, advantages? All this I have already explained in the previous video. Similarly, we also know what is a company form of organizations and its advantages and features. Today, this video will highlight and will help you in understanding the differences between these two forms of organizations. So, let's start with our video. Now, first of all, in limited liability partnership, the persons who form a limited liability partnership, they are known as partners. Whereas when we talk about a company form of organization, then the persons who are basically who invest in the company form of organization, who contribute towards the capital, they are known as members. So this is the very first difference between an LLP and a company. Now, whenever we talk about LLP, it is very important and it is mandatory that the LLP has to put a suffix, that is LLP, in the name. Okay, whatever is the name of the LLP, the acronym LLP has to be there in the form of a suffix at the end of the name. Okay, whereas when we talk about a company form of organization, basically here I am talking about a private limited company. So whenever we are talking about a company form of organization, always you can see that in the nomenclature, in the name, there will be a suffix, that is private limited. Why is it so? So that one can easily identify whether this form of organization is a LLP or it is a private company. Now, if we talk about the applicable act, then in case of limited liability partnership, the LLP Act 2008 governs the formation, governs all the provisions related to LLP, whereas a company form of organization is governed by the Companies Act 2013. Now, in case of LLP, the partners who constitute the LLP, they have to necessarily obtain designated partner identification number, which is known as DPIN. Whereas in case of a company, the directors of the company are required to obtain director identification number. Okay, this is the main difference between LLP and a company. Then we move on to the members. In the case of LLP, minimum 2 partners are required to form a LLP. However, maximum limit is not prescribed under the Act. Whereas in case of a company, minimum 2 persons are required to form a company and maximum can be 200 in case of a private limited company. Now, the main documents of a LLP are LLP agreement. Okay, all the provisions, all the regulations, all the rules will be stipulated in the LLP agreement that is executed between the partners. Whereas when we talk about a company form of organization, then in case of a company, the memorandum of association and articles of association are the main documents of the company. Now, in case of LLP, if we talk about, there is no mandatory requirement of any board meeting or any statutory meeting or any other EGM, AGM, no such requirement is there. Where in case of a company, in case of a private company or a public company, there are certain mandatory requirements for the conduction of board meetings, then AGM, that is annual general meeting, and other statutory meetings. So this is basically, these are the main differences between LLP and a company. Now when we talk about the similarities between an LLP and a company, the very first similarity between an LLP and a company is that in both the cases, the liability is limited. Limited liability means that the extent of contribution, okay, the contribution made by the partners or the members, they will be liable in case the company or in case the LLP goes insolvent or bankrupt. Then in that case, the members or the partners will be liable only for the nominal amount of contribution held by them. Okay, their personal assets or their personal property cannot be claimed, cannot be taken to pay off the debts of the company or the LLP. This is known as limited liability. Okay, whereas Whereas when we talk about unlimited liability, in that case, if the organization goes insolvent, if the organization gets bankrupt, then in that case, the personal assets of the members or the personal assets of the partners are basically used to pay off the debts, which is basically the case of partnership firm. So to overcome this disadvantage, LLP has come into existence. Okay, so this is the very first similarity between a LLP and a company. Then we talk about separate entity. Yes, both the organizations are having a distinct identity, separate identity from its members. Okay, the members will have a different identity, and the LLP or the company, it has its own identity. All the documents will be entered, all the agreements will be entered in the name of the LLP and not its partners or members, as in the case of company. Then we talk about perpetual succession. Perpetual succession means that even if all the partners of the LLP they die, okay, still the LLP will be into existence. The LLP will not come to an end. Members may come, members may go, but the LLP or the company, as the case may be, will go on forever. Why is it so? Because they are having a separate identity from its partners or from its members. So even if all the partners are dead, if all the members are dead, still the company will be into existence, still the LLP will be into existence. Now this LLP or a company has come into existence through a legal process. So therefore, if we want to end its identity, if we want to wind up this company, or if we want to dissolve this LLP, then again a legal process has to be followed. Okay, so these are basically the similarities between a LLP and a private company. I hope you understood the differences as well as the similarities. I will be back with another video. Till then, have a nice day and take care.